Ladies and gentlemen, welcome to our program. Scholars and Scribes review the rulings, the Supreme Court's 2023-2024 term. Please welcome Giancarlo Canaparo, Senior Legal Fellow in the Heritage Foundation's Meese Center for Legal and Judicial Studies.
Well, welcome to our annual Scholars and Scribes events where we review the Supreme Court's term. I could begin by saying it was a blockbuster term, but aren't they all, almost by definition. But analysis of the Supreme Court's decisions tends to be simplistic, performative, a little bit silly. Sound and fury signifying not so much an effort to educate, but to inflame. Thankfully for us, however, we have a panel of brilliant and diligent people who strive to educate rather than to inflame. So without further ado, allow me to introduce them. I'm going to give them all, in the interest of time, much briefer introductions than they deserve. But Professor Jen Mascott teaches and researches recently at the Catholic University Columbus School of Law after moving there from George Mason Law School. She writes on administrative law, constitutional law, interpretive theory, the separation of powers. She's written scores of law review articles cited by judges and justices at all levels of the federal judicial system. She's a graduate of the George Washington Law School, a former clerk to then Judge Brett Kavanaugh and Justice Clarence Thomas. Roman Martinez is a partner at Latham & Watkins, where he specializes in appellate law. He has argued 14 cases, is that right? As of this term, 14 cases before the Supreme Court, including one of the major cases we'll be talking about shortly. He graduated from Yale and served as, among other roles, assistant to the Solicitor General of the United States, also a law clerk to then Judge Brett Kavanaugh and to Chief Justice John Roberts. Jess Braven is the Supreme Court correspondent for the Wall Street Journal, a position he has held since 2005. Besides his journalistic work, he's had a fascinating career, continues to have a fascinating career, as an author, a public servant, and as an academic. His books include The Terror Courts and Squeaky, The Life and Times of Lynette Alice Fromm. He's taught at both the college and the law school level, served as a regent of the University of California, and as a commissioner on the Berkeley Police Review. He earned his law degree from UC Berkeley. And last but not least, Jimmy Hoover is the Supreme Court reporter for the National Law Journal. Before that, he served for more than 8 years as a reporter for the DC courts and on the Supreme Court for Law 360. His journalistic career started at least as far back as his college days, where he reported for the university's radio station and its student publication. He was also part of a startup, Law Street Media, designed to bring legal news to law students and young lawyers. So without further ado, please welcome the panelists to the stage. So it would be, I think, appropriate to start with probably the highest profile cases, the ones attracting the most sound and fury. So Jess, would you start us off with Trump versus the United States, the immunity case?
What was that one? Well, yes, Trump, that was the case that came on the last day of the term. The court extended its term into July, past the usual ending in June, and it even added an extra day to the argument session to hear Trump v. United States. And that obviously was a case that really, I think, people have been anticipating since the term began, maybe since the indictment was handed up in August by the grand jury here in Washington, D.C. The issue was what immunity from criminal prosecution, if any, does a former president have? And that was obviously something that has been hotly disputed in the I guess historically, as well as in the lower courts. So President Trump, not wanting to stand trial on the 4-count indictment, which Jack Smith obtained, argued that he was categorically, or his phrase, absolutely immune from prosecution for any of these actions because they were in the course of his obligations or duties as president. The trial judge, Tanya Chutkan, rejected that argument in December of last year. Trump appealed to the D.C. Circuit. Jack Smith, seeing where this was going, asked the U.S. Supreme Court to expedite the case and immediately take it up, as it has in some other highly contested cases. The Supreme Court declined to do so. The D.C. Circuit expedited its own hearing and decision on the case, and in February decided that whatever zone of immunity there may or may not be for a former president, it did not encompass the actions alleged against Donald Trump. And that was a three-judge panel made that finding in February. Supreme Court then took up Trump's appeal, again declined Jack Smith's motion to expedite the hearing and make a decision, or at least have an oral argument in March. Instead, as I say, it added a case, an extra day of argument in April. At the oral argument, I think that it became very clear which way the court was going. And it was, I think, sort of a surprise to some people who, at the outset of the term, or at least the early part of the term, thought that the fates had given the court a way to, if not satisfy everyone, at least not displease everyone, because there was another Trump case, the one Trump versus Anderson, involving the Colorado Supreme Court. And the Colorado Supreme Court had made a decision on even more uncharted waters about enforcing the insurrection clause of the 14th Amendment. So it seemed to a lot of observers that, well, look, you've got one case where a state court has gone into totally unknown territory to decide whether it can enforce this insurrection provision in the 14th Amendment. And to remind everyone, the 14th Amendment says that former officials, people who have sworn an oath to the United States, and then engaged in insurrection or rebellion, are ineligible to serve in state or federal office in the future. So the Colorado Supreme Court determined that that applied to Donald Trump. And so it seemed that, well, this case, state court going out on a limb. The other case, the arguments for some kind of criminal exposure for former presidents seemed pretty strong, looking at the Nixon example from the 1970s. So, but that was not where the majority of the court was. What oral argument, it was very clear that the majority was concerned about the precedent it was setting going forward. In other words, forget about the specific allegations against Donald Trump. Imagine some future president who takes some controversial action, and then imagine another future president who succeeds him and appoints a terribly corrupt, bad faith prosecutor to bedevil his predecessor, and imagine that specter hanging over all future presidents. It would make them too timid to ever take controversial actions or do the bold things necessary to protect the national interest. And having that kind of cloud hanging over future hypothetical presidents was the risk that the Supreme Court needed to prevent by using this case and taking a very close examination of what the allegations were. And so the Supreme Court's ultimate decision, 6 votes for most of it, 5 votes for all of the majority opinion, were that presidents, after leaving office, are absolutely immune for criminal prosecution for their official acts related to their constitutional powers. And those, for instance, include communications with the Department of Justice and the president's underlings and appointees in the Justice Department. So those were absolutely immune, and not only could they not be prosecuted, even if there were some actions that were not immune from prosecution, the prosecutors could not even inquire into those. Like, they could not be used to support a prosecution on other acts that were legitimately charged. Simply can't go there, can't get into the president's head, can't examine the motives. That core of absolute immunity has to be sacrosanct. Then there were other areas that the court said were presumptively immune, and those involved communications with other government officials and potentially even communications to the public through the bully pulpit feature of the presidency. So what about Vice President Pence, who in his capacity as president of the Senate was presiding over the joint session of Congress that we probably paid more attention to than any other joint session of Congress? Well, those might or might not be entitled to immunity, and that was one of the questions that was sent back to the lower court. Because what branch is the vice president exactly in? Or how many branches is he in? Or is he his own branch, as I think Vice President Cheney once suggested he might be? So that was one of the questions that was sent back for examination by the trial court. Then there were questions about, well, what about discussions with state officials? The president has no direct relationship with state officials. But the president does have a sort of general interest in promoting democracy. If that's what President Trump was doing when he called the Secretary of State in Georgia and the other alleged acts, maybe that was also entitled to immunity. Another question sent back to the district court for examination. And then there were things that the president's attorney even said at oral argument would not be entitled to immunity, and those would be private actions by a president. And what is a private action? The court actually did not say what a private action was. It said these things are absolutely immune, but are these other things unofficial actions or private actions that are not absolutely not immune? Court didn't say, and was chided actually by Justice Barrett, who in a concurring opinion said the court should have gone further in explaining what were clearly private acts that were not entitled to immunity. But all those things were handed back to the lower court to figure out. There was a quite stinging dissent, which saw this as very much a sky is falling situation where, in effect, any president was immunized from prosecution for any use of his constitutional powers. So, for example, the famous SEAL Team 6 example, could the president tell SEAL Team 6 to go and assassinate an enemy? Well, you know, I'm not giving legal advice to anyone, but seems like you could, because president is commander-in-chief, Army and Navy have to report to him. Now, the members of SEAL Team 6 would not be immunized necessarily. On the other hand, maybe they could be pardoned. So, you know, what was to stop a president other than his overwhelming display of good faith from doing that kind of thing? So those were the issues that the dissent brought up, and they made other arguments saying that this was a novelty that the majority had essentially invented beyond the text of the Constitution. So have I missed anything?
No, I think you've covered the whole thing. Does anybody else want to weigh in on the panel?
Jen's gonna weigh in.
No, I'm good. I'm gonna hold tight.
Well, then I'll just chime in to say this is obviously having overtaken the other big Trump decision of the term in Trump v. Anderson in terms of the, you know, the public discourse. But it will be interesting to see now that this novel ruling on presidential criminal immunity is out there in the ether, how it affects the behavior of presidents going forward. I don't think either the majority or the dissent really can put a thumb on just what it's going to do in terms of the actions of the president. So
You've changed your mind.
Actually, I will say a couple things. One is, I mean, this is totally a novel issue in the sense that this is the first time we've looked at the question of whether a past president can be criminally prosecuted for things he did while in office. But actually in 2000, the Clinton administration answered the question about lots of criminal prosecution during one's term in office. So all of the examples that you give clearly under the Clinton administration, Office of Legal Counsel opinion, president could not be criminally prosecuted while in office for doing any of those things. So comparatively, this is obviously like a much different, much more modest opinion. The distinction is we're talking about for all future time, whether he could be criminally prosecuted. And then the other thing, you know, obviously the SEAL 6 hypothetical, the dissent, is raising as many troubling scenarios as it can because it's resisting the principle of the whole majority opinion. But on the whole question, first of all, about like assassinations or even what we do with enemy combatants, I mean, the court essentially said if it's a shared area of power, it falls only within presumptive immunity, not absolute. And folks, I'm sure on the stage will remember all of the Supreme Court decisions after 9/11, where the court at least claimed some role in determining whether we could name somebody an enemy combatant, what due process they got. So under that theory, that may be an argument for why a president can't just take whatever action he or she wants, even in a national security context, under this absolute immunity category.
Well, the president can't take any action he or she wants. We know from the steel seizure case and many other cases, the issue is rather whether what the president is doing is so villainous that it moves into criminal territory. And so that's, I think, the personal, the sense of personal exposure for going to jail for ordering people assassinated. That terrible specter has been removed from the burdens of our future presidents.
But I guess that's sort of the assumption that I am contesting, because I think I'm making the argument that perhaps it actually falls into that middle bucket where it's still an official act but subject to potential prosecution if the court's test is really areas that fall subject to shared authority and the court believes it has jurisdiction, at least at some times, to weigh in on how an executive branch treats enemy combatants and other alleged villains against U.S. interests. So we just don't know. I mean, the other one final thing I'll say about the opinion is the court actually told us that it very intentionally did not resolve all these issues because the court likes to sit as a body of last resort. And these issues have not been fleshed out by lots of courts of appeals or extensively over time below. And so I think it felt as though it needed to issue a ruling in this important case, but it didn't want to answer all of these issues for all future time. It intentionally kept a lot of them open, and it just means Jack Smith and others will have a lot of work to do arguing the law and the facts on remand as this case goes back down to the district court.
So I was struck by this opinion by what it left open and the number of things it left open, even in this particular case, to be resolved below. When Jess summarized the case, and I think Jen echoed this, sort of categorizing the middle category. You have the core executive powers, absolute immunity. I think both of you described the middle category as being presumptive immunity. I read the opinion to say at least presumptive immunity.
Maybe that's right.
Such that it actually left open the question of whether in the middle category, where it's not core exclusive presidential authority, but rather with the set of things that both Congress and the president can jointly kind of have room to maneuver on under the Constitution, as to those activities, the court actually does not decide whether it's absolute immunity or presumptive immunity that you get. Maybe I'm wrong about that reading, but if that's true, I think they're kicking that question to Judge Chutkan, which is very surprising to me, because that seems to be a pure question of law, directly implicated in the case. If she finds that any of these actions that are alleged in the indictment fall into that middle category, she's then going to have to decide for the first, in the first instance, whether the Supreme Court's decision requires absolute or presumptive immunity for that. I think that's a very big decision. It's a little odd, I thought, that they kicked that back down. I also think that the court was not entirely clear on the boundaries between the three different categories: the core authority, the middle category of sort of shared authority, and the final category of private acts. And I was surprised that they didn't say more to tackle the hypotheticals, the SEAL Team 6 hypothetical and the bribery hypotheticals that were so important at argument. I was almost shocked that they didn't address those. The Chief Justice who wrote the opinion, I thought, was very sharp at argument in drawing out from former President Trump's attorney, sort of the consequences of his position and the challenges of saying that taking a position that made it look as though bribery might be immunized. And I just thought it was a little strange that they didn't directly address that. The dissent says bribery is now immunized. Justice Barrett says it's not immunized. The majority opinion seems to, the logic of it arguably suggests that bribery might be immunized, but then they have a footnote that responds to Justice Barrett that sort of proceeds on the assumption that it isn't immunized, but it never explains quite why. And so I'm kind of left with a lot of questions about what the law is after this decision.
Just one last thing on that. At the Sixth Circuit conference this year, Justice Kavanaugh was speaking, and he said, you ever see a footnote in a Supreme Court opinion that seems to undermine everything else that's in the opinion? He says, when you see that, that means that there was some disagreement going on, and that footnote was sort of necessary to keep everybody on board. So this case hadn't been decided then, so I'm sure he wasn't talking about this, but that's one thing.
I read the decision as sort of behind this. Between the lines is that I think the 5 justices who joined the majority, other than Justice Barrett, who wrote separately, I think there were significant disagreements about some of these issues among those justices, and that's why this decision is written in a way that it doesn't resolve even some pretty important issues relevant to this case.
Jimmy, to pivot away from this case in the interest of time only, because we could probably spend the whole day, there was another Trump case, which was the hottest potato for a very long time until we all forgot about it. Trump versus Anderson. Can you walk us through that one?
Yeah, this was the big Trump case until it wasn't the big Trump case. So this is the case out of Colorado that Jess helpfully kind of laid the groundwork for a little bit, discussing the immunity decision. but it is the question of whether former President Trump was disqualified from office under Section 3 of the 14th Amendment, which was ratified during Reconstruction after the Civil War. And I have it kind of just jotted down here with, I won't read the ellipses, but basically for ease of understanding, Section 3 says, "No person shall hold any office who, having previously taken an oath as an officer of the United States to support the Constitution of the United States, shall have engaged in insurrection." So there was an argument that kind of bubbled up in the legal academy and eventually made its way into a bunch of courthouse doors around the country from a lot of Democratic voters and progressive litigants who argued that Section 3 disqualified former President Trump over his role in the events of January 6th for allegedly having incited insurrection against the United States. Now, this was kind of an off-the-wall theory that didn't really make a lot of news until the Colorado Supreme Court last fall decided that, in fact, Trump was disqualified under Section 3, acknowledging, as Jess said, that we were in totally uncharted waters here, going through and finding that Trump met the criteria that was announced in what had long been a pretty kind of not very, an obscure provision of the Constitution. And so this decision by the Colorado Supreme Court made instant national news, and it was pretty clear at the time that the Supreme Court was going to have to say something about it, given that Trump, with the Republican primary election just a few months away, was now barred from appearing on the ballot. Now, while this case was going up through the court process, the effect of that ruling had been stayed, so Trump's name was preserved on the ballot until basically the Supreme Court could weigh in. And former President Trump took until, I think it was the first week of January, to file his Supreme Court petition. And it was a pretty clear sign that the Supreme Court was going to have a lot to say about this decision when it granted Trump's petition just 2 days later and set oral arguments for the following month. So this was by the standards of the Supreme Court, a pretty rocket docket timeline for them. And there was a very expedited briefing. The case was argued in early February. And at oral arguments, it became pretty clear that the jig was up in terms of using this Section 3 mechanism to disqualify Trump from the 2024 presidential election. A lot of the Republican appointees on the court expressed serious doubts about this theory that was being pursued by the then respondents in the case. Particular Chief Justice Roberts kind of framed this one as an issue of the constitutional restructuring that took place under the 14th Amendment, saying that this was something that was essentially designed to shift power in favor of Congress away from the states. So why would it be that we would read this particular provision to suddenly empower every state around the country to decide to disqualify a federal candidate for national office? And you even saw the same concerns being expressed by some of the Democratic appointees on the court, like Justice Elena Kagan, which is usually a tell that you're going to lose about 7-2, if not 9-0. And so that's exactly what we saw when just before Super Tuesday, the Supreme Court announced a per curiam decision, kind of hearkening back to their per curiam in Bush v. Gore. I guess that's what they do in big, high-profile election cases, in which they kind of embrace that same logic, that Section 3 does not give states the authority to disqualify federal candidates for federal office, and that, the court could have stopped there, and that's exactly what some members of the court wanted the court to do, but in fact it went a bit further and pointed to Section 5 of the 14th Amendment, which gives Congress the power to pass appropriate legislation to essentially give effect to the amendment, and that's what the court said should be done in the case of Section 3 for enforcing this insurrectionist ban, which is to say that if you want to kick someone off the ticket for to run for president, it has to be through basically legislation passed by Congress, not up to the individual states. And that's where you saw a little bit of that's where you saw the court fracture. You saw Justice Amy Coney Barrett expressed in a concurrence that she would have had the court just stop at kicking the case back and saying, no, this is not an issue for the states. But separately, you had a much more fiery concurrence that one reporter pointed out had originally been styled as a partial dissent before it was changed. And in that concurrence, erstwhile dissent, whatever you want to call it, Justice Sonia Sotomayor really took the conservative majority to task for overstepping, in her view, and deciding a future case that wasn't actually before it, and kind of narrowing the ability of, I suppose, the federal government to give force to Section 3, this long dormant insurrectionist ban. And it's hard to see this case as something other than a kind of a missed layup when you have such a highly charged political dispute that seemingly the justices are all in agreement on, and yet at the last second you have this kind of bitter row over just how broad the scope of the ruling was. And Justice Barrett's concurrence that I mentioned earlier kind of took even though she agreed with the three liberal appointees, the three Democratic appointees on the court, kind of took them to task for raising the pitch of the rhetoric in the case. So that's kind of the long and short of it. And like I said, it's been completely overtaken now by some other big decisions this term. But at the moment, it was the legal dispute du jour.
Let me move us into another big category of major cases this term, the court's administrative law decisions. And Roman, I'll pitch it over to you first, since you argued Relentless, which was the companion case to Loper-Bright. So why don't you tell us about those cases?
Sure. Before I do that, let me just acknowledge my friend and colleague, John Vecchione, who's here, who's co-counsel in the case and led up the team litigating the case up through the Supreme Court stage. So the case involved fish. At one level, our client, a commercial fishing outfit in New England, they followed the law. The law requires them to carry federal observers on their vessels. No issues with that, no complaints about that. The problem was the federal government ran out of money to pay for the observers, and so they decided that even though the statute didn't authorize this, they said, well, we're going to force the fishermen to pay for the observers on the boats. And they estimated at the time that the costs of this new regulatory program could be as much as 20% of the annual profits of some of the fishermen affected by this. So our clients challenged the rule. It was litigated through the lower courts. There was also a parallel case challenging the same regulation, also litigated through the lower courts. And ultimately, the First Circuit and the DC Circuit in the two parallel cases agree with the agency that their program is lawful, applying the Chevron framework. And accepting the agency's arguments that the statute was silent as to who pays for the observers, and applying Chevron to statutory silence, saying, well, we got to defer to the agency if they're reasonable in a circumstance where there's silence or ambiguity. And then the agency's program is upheld, essentially, because the statute is in theory, silent. So the case comes to the court, though, and the issue is not so much fish or this particular regulation, but rather the Chevron deference doctrine generally. And as I'm sure many of you are aware, the court ends up overturning the Chevron deference doctrine. With respect to the, thank you. With respect to the rationale, there were a number of options that the court had for how to resolve the case. The three main ones were, there was a constitutional theory that the judges have, as an inherent in their judicial function, they have the obligation to, the responsibility for saying conclusively what the law is on behalf of, in litigation. They have that duty to exercise independent judgment when making that determination. And neither Chevron nor Congress nor anyone can take that sort of inherently judicial authority away and hand it over to an agency in any cases, but not even in cases where the law is ambiguous. There was also a constitutional due process argument that we raised as well. In addition to the constitutional arguments about the role of the judiciary and due process, there was a statutory argument that the Administrative Procedure Act, the kind of seminal statute governing regulatory litigation against the government, that itself created an obligation that sort of embodied the Marbury versus Madison rule of the court being the one to say what the law is, and that the APA itself required courts to exercise independent judgment. And then there's a third argument, which is less of an affirmative argument and more of a response to the justification for Chevron, The old justification for Chevron deference had been that when there's an ambiguity in a statute, this means that Congress intended to delegate to the agency the power to resolve the ambiguity. So a court is just following Congress's implied delegation and deferring, and that's what Congress wants it to do, so that's what the court should do. That was the principal justification for Chevron. And so we had a third argument that even if you didn't buy the Constitution, even if you didn't buy the APA, this affirmative justification for doing Chevron deference just didn't hold up and was based on a fiction, that Congress does not in fact intend every time it has an ambiguous statute to delegate. So the court's decision in this case rests on the APA argument that we had put before it. But I think it also accepts our third argument, which was that the delegation theory is bogus, it's a fiction, it's not real, it's made up. The court didn't address the constitutional theory directly, although I think a lot of the analysis of the APA issue talked about the history of the American judiciary and what is inherent to the job of judges, the role of judges, how judging was understood at the time of the founding. And I think it's very consistent with the constitutional arguments we made, even though the majority did not end up saying that it was resolving the case on constitutional grounds. So the decision ends up being 6-3. Justice Gorsuch writes a concurrence talking about his view of stare decisis and some of the constitutional issues. Justice Thomas writes a concurrence talking about the constitutional issues and being more express in embracing our constitutional arguments. There's a very vigorous dissent by Justice Kagan as well. But ultimately, the law now going forward, judges need to be judges. They need to exercise independent judgment. They're in charge of saying what the law is. A couple of just quick comments on what the decision means and some of the caveats that are embedded in the decision that might lead to further litigation. I think there are three things in the decision that are going to be important going forward for litigants and that are still somewhat open questions about how this is all going to work out in practice. Number one, the court did not excommunicate federal agencies from having any role and even a role in the statutory interpretation process. The court says that judges need to exercise independent judgment and have the final say as to what the law means. But it says that there are canons of construction that would lead judges to look to longstanding and consistent interpretations by agencies, and that should be a factor in their sort of historical analysis when they're deciding independently what the law means. The court also seemed to resurrect the Skidmore doctrine, which says that courts need to give respectful consideration and give weight to the agency's views, especially when the agency is talking in an area where it has expertise. So ultimately, the judge is still in charge, but the judge needs to take it seriously into account what the agency has to say. I think a second caveat in the decision is that the court makes clear that there are certain types of delegations to agencies that don't implicate the Chevron deference issue because they're really delegations of policymaking type authority. And Congress still, the court says, can delegate certain types can give agencies policymaking discretion and flexibility in certain ways. And when they do that, when Congress does that, courts need to respect those delegations, even while the courts have to police the boundaries of those delegations. I think there's very important language in a couple places in the opinion that's going to give rise to a lot of litigation about exactly what that means, because I think agencies are going to start asserting that, no, we're not doing interpretation, we're just doing policymaking. You still need to essentially defer to us, subject to other doctrines of administrative law. But I think that's kind of an open question about how that's going to get cashed out. The final thing I'll say is that the court didn't want to be too chaotic in its ruling. And so it said that with respect to old decisions that had upheld agency programs under the Chevron framework, those old decisions don't automatically go out the window just because Chevron has been overturned. It said that the bottom line holding in those old decisions, which was that agency program X, Y, or Z is lawful, those remain good law, even if the reasoning that led to those decisions, based on the Chevron doctrine, has been undercut. And I think that was an effort by the court to sort of limit the backwards, the retrospective effect of its holding on cases that had previously been decided. So ultimately, I think this is a very good decision for our country and for the constitutional separation of powers. But I still think there's some open questions that are going to have to be sorted out as agencies and litigants go to battle in courts under this new regime.
Other thoughts from the panelists on the Chevron cases?
Would you call this a sort of very long-term victory for Justice Ginsburg, because wasn't she overturned in the original Chevron case? I mean, I believe.
Is that right? I hadn't focused on that.
I believe that she was on the D.C. Circuit panel that took the position that you argued that judges should be able to say this. And as we know, Justice Scalia was a supporter of the Chevron doctrine. So one thing, this is a way into. Just
I think Justice Scalia came around later in life, and I'm glad to see that Justice Ginsburg, who I had a lot of respect for, she would have voted for us in the case, Jess.
Well, what was interesting is that the case arose obviously because judges were second-guessing Reagan administration decisions to deregulate. In fact, Justice Gorsuch's mom was the respondent in this case originally, and later the title was changed. And one thing that I thought was sort of interesting is that yes, the positions turned at the time that the administration wanted agencies to have great deference against a liberal D.C. Circuit. That was a position they took, and then obviously things changed, the dynamics changed. So there was a lot of questions I know around observers of the case of how much of this is really principled and how much of this is just because who occupies which seats. But and that's also true for the NRDC, the original plaintiff in the Chevron case, Natural Resources Defense Council. I spoke to the lawyer who argued the case for the NRDC in the 1980s, David Dyer.
He switched sides too, right?
Well, he filed a brief in this case affirming the precedent. He said, it's like what a bookend for my career to begin and end with a Chevron case and be the loser both times.
Right. Well, I think your point actually about the kind of the effect of overturning Chevron, I don't think it's like inherently partisan or political. And I think that we may see that if President Trump is back in the White House, in a year, he's going to presumably be thinking about deregulation in a bunch of different areas, and he's going to get less deference than he would have gotten under the old regime.
Well, also, I think another way to conceptualize this is to see this as a return to the historic status quo in a sense, because, first of all, the APA was enacted in 1946, so there were 40 years of interpretation of statutes before anybody came up with the Chevron idea, and that decision was issued by just a 6-member court. Only 6 justices heard the case that day. And also then, of course, hundreds of years before that, agencies and courts were having to interpret statutes. And the court, it should be noted, the Supreme Court hasn't actually been applying Chevron deference in cases for the last 10 years. So I stick with your overall bottom line, Roman, that I think, this is a significant decision. At the same time, I think there are many reasons why it's not going to necessarily lead to some of the seismic shifts that the more controversial commentators were suggesting.
Jen, can you lead us into a discussion of the CFPB case?
Sure, you're done with Chevron. We're ready to move on. Okay, I'm happy to do that. And you've assigned me 2 admin law cases, like Cargill and CFPB, because I was going to flip the order.
By all means.
That's okay.
Absolutely.
So building on Ramon's point, because I think he mentioned also that the Loper, Bright, and Relentless decisions, the court decided them on a statutory basis instead of a constitutional basis. And the point I'm going to start with might sound a little strange when we led off with the 2 very juicy Trump cases at the beginning, but I think in a lot of ways, this term, following on the heels of the affirmative action decisions last time and the gay wedding cake and free speech, and then the term before that, Second Amendment coming into light again, and the reversal of Roe versus Wade and Casey, that this term surprisingly was a lot more of a statutory and perhaps even a procedural and jurisdictional term. So the court had a number of constitutional cases poised, decisions it could have issued, and it rejected the constitutional claim, and that's true in the CFPB case, where it had the chance from the Fifth Circuit to kind of broadly apply appropriations clause limitations. It declined to do so. It declined to find a Second Amendment problem with domestic violence, gun restrictions. And then in other areas, like with the abortion pill, mifepristone, it declined actually to hear the case on the merits. And even one of the January 6 cases, the one dealing with the obstruction statute, that was really a question of statutory interpretation where Justice Jackson joined the majority. So in a lot of ways, the court this time, I think, was doing more, dare I say, run-of-the-mill decision issuing. You saw some surprising alignments, one of which comes up in the CFPB case I'll talk about, and then you saw statutes and statutory interpretation really playing a center role as opposed to always grand pronouncements. So I think that actually explains the Cargill decision, which seems a little bit juicy because it's dealing with bump stocks and machine guns, and it came out of a regulatory action that was motivated by a really serious concern. Just the terrible violence in Las Vegas, Nevada in 2017, where I think there were 58 fatalities and more than several hundred other folks were wounded. And it was actually the Trump administration that made the regulatory decision to classify bump stocks as machine guns. And just to explain, I mean, what that means for those, I mean, anybody who's a firearms expert here, I am not one, so maybe you'll be correcting me, but essentially, I mean, the court was looking at statutory language that said if it's a machine, something's a machine gun, if with one movement of the trigger, multiple shots can be issued. And so in this instance, if you put a bump stock on a semi-automatic firearm, it makes it operate more like a machine gun. But the court essentially looked at the statutory text and said not enough to actually classify it in this stricter machine gun category. So it's a statutory decision. I think what was really motivating a lot of the justices is that the Bureau of Alcohol and Tobacco of Firearms had historically not classified bump stocks as machine guns. So they fell under less severe regulation. So people actually owned firearms, were using bump stocks, and when the change took place in 2017 under the Trump administration and then continued during the Biden administration, so it was a Biden administration lawyer who was trying to defend this decision and this action, the ATF had actually changed a historic position on the issue, and there are criminal penalties in play. And so the court, you could really hear at oral argument in particular, was motivated by this concern that people who made decisions thinking they were lawful were now potentially going to face criminal penalties unless they turned back in their souped up firearms that had now become criminally classified as machine guns under this decision. But at the end of the day, it's a statutory case, and it was a 6-3 majority, and Justice Alito wrote a very short separate concurrence simply to point out that there is an answer to this in our system if one is concerned the guns are not regulated too heavily in this particular area, and it would have been for Congress to address the statutory language. And of course, that's often the answer when agencies are acting. It's not that the court's necessarily always saying the government can never do it. It's saying who has the power to do it. In this case, Congress would have to change the statute. The ATF can't make willy-nilly changes that criminalize behavior that previously was lawful. So that's all I have on that. Should I pause for commentary from
Anyone else on Cargill?
Well, there was an interesting question, I think, at oral argument about, other than evading the text of the statute, what's the benefit of a bump stock? In other words, what's the benefit of this device other than being able to get around the ban on machine guns? And the answer was from Mr. Cargill's lawyer was, well, maybe disabled people have trouble, loosing fusillades of bullets, and this device, helps compensate for a physical disability by allowing you to shoot rapidly. So you can think of it as a disability rights case.
CFPB, go for it.
Okay, all right. So the Consumer Financial Protection Bureau, just the headline most interesting part, in my humble view of this opinion, is the 7-2 nature of the decision led off by Justice Thomas, who we all know does not shrink away from strong decisions and from questioning agency power and from looking closely at constitutional claims. And this was actually a rejection and a reversal of the Fifth Circuit's determination that the funding scheme through which the CFPB gets its annual and ongoing funding was thought to be a violation of the Appropriations Clause by the Fifth Circuit, and the court was saying 7-2. No, indeed, it wasn't. So an interesting lineup there. I'm just going to pause and say I think, again, I really do think all 9 justices are trying to decide these cases according to their view of the law, the Constitution, that they're not overly political, they don't have a predetermined bottom line in most cases. And here we see this instance of 7 justices, including some who often are ruling against the government, and really closely interpreting the constitutional text here, declining to read the appropriations clause more broadly and more strictly than they thought it was due. The other point about the case is it was just one of several instances where we saw the Fifth Circuit Court of Appeals, and this comes up in the Jarkissi case that we'll talk about later, where it was finding lots of constitutional violations and granting lots of constitutional claims. And it was putting the court in a position where it would have to rule on these cases, whether it thought the issue really was ready or not, because the Fifth Circuit was finding major agency action to be unconstitutional. And so the court's hand was perhaps forced to reach more of these issues than it would have in any given term. It wasn't really reaching out to say this is an important issue as much as responding to the Fifth Circuit's rulings. And then also the Fifth Circuit chose to make the ruling here more constitutional when there were some other grounds that perhaps would have been easier for the litigator Noel Francisco to defend going up to the Supreme Court. So it was just an interesting strategically or just with trends about how the court and lower courts are deciding cases. On the merits of it, essentially, the Consumer Financial Protection Bureau gets its funding very differently, many of you may know, from the typical agency. Normally in this town, we know all about the annual appropriations process. It leads to shutdowns of government, very exciting, controversial moments in the fall, in the winter around town, but not the CFPB, because the CFPB gets its funding by the director going to the Federal Reserve and saying, I need this much money, give it to me now, I have statutory authority, everybody listen to me. So the people are unhappy about that because they don't like the CFPB's got strong regulations. People don't like a lot of its actions, and so the constitutional challenge was this cannot possibly be consistent with the appropriations requirement, which says, and interestingly, actually, it's in a portion of the Constitution, Article 1, Section 9, that is not actually granting power, unlike Article 1, Section 8. It's restraining and saying what we can't do. And it says, no money shall be drawn from the Treasury, but in consequence of appropriations made by law. And that's actually, even though we don't think about it a lot, quite a significant provision. And it's the reason why the government shuts down, obviously, when the appropriations process reaches a stalemate, because it's actually unconstitutional for the federal government to continue spending money if there's not actually law authorizing it. And where do we get accountability from for the executive branch? Well, one of the tools that Congress still has decided to continue to use is passing bills to appropriate funding. And so it seems challenging to know how the CFPB or any agency is going to be kept accountable if Congress essentially makes the policy determination not to regularly use its power to reauthorize appropriations and instead gives one agency essentially an entitlement within a certain amount of funding. I mean, I was trying to be facetious and sort of overly dramatic earlier. I mean, there are caps on what the CFPB can get, but essentially it can decide each year how much it needs for its budget. But the court, looked at history. It looked at the meaning of the terms. It looked at the text of the provision, and it also distinguished that provision, which seems pretty general. No money shall be drawn out of the Treasury, but in consequence of appropriations, and contrasted it with the one other. I mean, there's a couple other, but one other really clear reference to funding in the Constitution is about raising money for standing armies, and you can't have an appropriation that lasts any longer than 2 years for a standing army. And so the court, I think, also made the point, well, it doesn't give that time limitation about anything else. So we certainly can't see from the text of the Constitution that there's necessarily some one-year requirement that Congress appropriate funds every year. And we also don't necessarily see a requirement that the law that authorizes the appropriation take a particular form. So even though this one was more indirect, and it essentially gives the CFPB director the ability to go get money out of this a little bit more, not an opaque pot of money, that the court didn't really see it as truly violating that constitutional provision best understood. And so I think for those of us who just are concerned about the exercise of government power in general and want to make sure that our jurists are taking a principled approach, we can take heart, because I'm quite confident, just if you read other decisions and other thoughts about administrative law, that a number of the justices in the majority are quite concerned, I'm sure, about many other aspects of the CFPB structure and the exercise of administrative power. But on this day, with this particular provision, the court said, we don't see the violation there. And so it reversed the Fifth Circuit's determination on that ground.
Ramon, you wanted to weigh in?
Yeah, I just think big picture of this case is interesting because it's part of a significant subset of cases that were sort of, I don't know if you want to call them like sort of conservative cause litigation, or there were a lot of these cases on the docket this term. Some of them important ones successful, but there were a lot that didn't ultimately get 5 votes. So I think of this case, the 2 abortion cases, the Murthy case, net choice, which is more about conservative state governments, Rahimi in part. Like there were a lot of these examples where you saw, someone could look at that and think maybe there were conservative litigants out there that were overreaching and trying to get the court to do more. I think the court itself, leaving aside the merits of the particular decision, I think the lineups in those cases had, cross ideological majorities resolving them, which, whether you think those decisions are right or wrong, I do think it puts the lie to the idea that this is a kind of, runaway conservative majority that's some sort of monolith that's just going to do politics in every case.
It's interesting, just to kind of quickly chime in, all the cases you just mentioned came out of one federal appeals court, the Fifth Circuit, and so
Right.
there's kind of an ongoing discussion. Is the Supreme Court kind of doing some course correction to the lower federal courts of appeals that were largely, reshaped under the previous administration? And the Fifth Circuit is a leading example of that has become, I guess you could call it far more conservative. Some people would call it far more constitutionalist, whatever you want to call it. They're coming out with aggressive, bold rulings on things like the CFPB. And I mean, that was a case that also I spoke to a number of consumer protection lawyers who were fearing not just the argument about the appropriations clause there, but also the remedy of vacating what the CFPB had done and potentially seeing that Fifth Circuit ruling as a way to kind of undo everything that the CFPB had done. I mean, they were really screaming that the sky was falling in that particular case. So it is another example of this current Supreme Court kind of admonishing in pretty gentle terms and not anything personal, but some of the lower courts of appeals to maybe slow down. I don't know if you guys agree with that's.
I think in defense of the Fifth Circuit's record, I think there were a lot of cases where they lost. I do think it's important to note that there were also some important ones that they won.
Yeah.
Cargill, I think, was Fifth Circuit, right?
Yeah.
And then maybe most importantly, and extremely important for the administrative state, Jarkissi. So there is nuance even there. But I agree with you that it did seem like there were a lot of Fifth Circuit cases out there.
I think, Roman, I think we were at this event where there was a liberal law professor who described the Fifth Circuit as sort of the meth lab of the conservative legal movement. So, trying really out there.
That's not fair. And the Ninth Circuit just hasn't had its day. It had many terms, the Ninth Circuit. But I think more broadly, I think the court, to your point, Jimmy, is yes, and to Ramon's point, and Jess has said this as well, it is not the branch that's supposed to reshape government and policy and fix administrative agencies. And so it's just going to decline where the text of the Constitution's not there, where it doesn't speak to the question, where there's not standing, it's not a case for controversy. It's not going to step in. Litigants, I think, are feeling nervous and motivated because, as we all know, Congress just doesn't take action often to fix these problems perhaps as readily or quickly or easily, partly by constitutional design as some would like. But at the end of the day, if it's terrible policy or we have concerns about the CFPB funding scheme, it's not that folks are without hope. Maybe efforts need to be directed toward lobbying the legislature. And good news, it's really close by. It's just a block or two away, and they can change the CFPB funding scheme this year if they want.
In the interest of time, let me pivot us to some of the civil rights cases. Jimmy, would you lead off with Rahimi?
Oh, Rahimi, sure. So this is kind of the big gun rights case, putting Garland versus Cargill to the side, because that's more of a statutory case. This was a big Second Amendment case this term involving a federal statute, Section 922G, that makes it a crime for someone who's been found by a court to possess a credible threat of domestic violence, to own a firearm. It's a criminal prohibition. And the Supreme Court, in an 8-1 decision held in U.S. versus Rahimi, or I should say, it rejected a Second Amendment challenge to that federal statute in the case of a defendant named Zaki Rahimi. It didn't necessarily uphold it in all instances, only to say that in this particular case, the defendant, a gentleman that was a drug dealer with a kind of very checkered criminal history, who had been, accused of assaulting his girlfriend, threatening her with a gun, being involved in multiple shootings, and a number of other drug crimes. That when applied to him, that this was not a violation of the Second Amendment's right to bear arms. And I'll just read from kind of the bottom line holding of the court here, written by Chief Justice John Roberts. When a restraining order contains a finding that an individual poses a credible threat to the physical safety of the intimate partner, that individual may, consistent with the Second Amendment, be banned from possessing firearms while the order is in effect. So this was the big test of the Supreme Court's 2022 decision in New York State Rifle and Pistol Association versus Bruin, where, authoring the majority opinion in that case, Justice Clarence Thomas said that modern firearms, when assessing the constitutionality of modern firearm regulations, you kind of have to go back to the time the Second Amendment was adopted to see what kind of regulations were in place and find historical support, historical analogs. And in this case, the Fifth Circuit below found that there was no sufficient historical justification for this ban, pointing out that domestic restraining orders come before or in the absence of an actual criminal conviction, and saying that it's basically not justified, and it would never have been supported by the founders of the country and the drafters of the Second Amendment. Now, the Supreme Court's majority decision, it was an 8-1 decision. Notably, the one dissenting justice was the one who authored the Bruin decision himself, Justice Clarence Thomas. But the majority basically said that the Fifth Circuit had demanded too much in the way of this historical inquiry, and that instead they should look to see whether there are historical examples of firearm regulations with relevant similarities. In this case, laws basically going to the bottom line principle of when someone has been found to pose a credible threat to the physical safety of another person, it's common sense to get rid of a gun. Now, Thomas basically thought that was a refashioning of his decision in Bruin, and said that he would have demanded a kind of a higher historical analog for that justification. Now, a lot of commentators have pointed out that, of course, you're not going to find a historical analog for this type of firearm regulation, as domestic violence wasn't even recognized as kind of a widespread societal issue at the time in the late 18th century. But nevertheless, the Fifth Circuit and Thomas explaining in his dissent that that is exactly what the Constitution demands in this case. So I'm curious to hear what the panelists think of whether this decision is kind of a retreat from the standard that the court announced in the Bruin decision from 2022, or if Roberts' take on it that the lower courts are basically misreading it and demanding too much of Bruin in going and scouring the law books from the 18th and early 19th century for these kind of regulations.
Well, my question is really this. Test cases have a history of trying to find incredibly sympathetic plaintiffs, and that's fine. That's been the case since Plessy versus Ferguson. Homer Plessy was someone who was part of an engineered case. It didn't succeed, but the aim was to fight a segregation law. And here it seems that the Solicitor General sort of played the card the other way. The other firearms cases that the court has used to expand gun rights had fairly sympathetic, or at least responsible parties at the center of them. It was as if the Justice Department said, let's find the most reprehensible possible person to have a gun. This guy who's shooting up Whataburgers, brandishing weapons, he's just, he's like the anti-test case character, the exact person you don't want with a gun. And I wonder if the facts of this case, you think, colored the way the majority began examining the implications of the Bruin decision.
I mean, I think you heard that from Chief Justice Roberts at arguments when he was asking, do we really want dangerous people to be having guns? And the federal defender representing Rahimi said, well, what do you mean by dangerous? And he said, well, start with shooting at everybody. That's a good start.
Like your client did, right?
So, I mean, I think you're totally right. This is the most unsympathetic plaintiff or defendant that you could ever choose for a gun rights case, and that's why I don't think there was a lot of expectation that this was going to be the case that, or even really a lot of animus, or excuse me, a lot of like energy on the part of the gun rights movement to even, defend Rahimi in this case, or challenge the particular gun regulation at issue, this Section 922 that's been on the books for decades. It just seemed like this was another case where, I don't think it would have been the one that the gun rights movement would have chosen for the Supreme Court to start examining the scope of the Second Amendment.
Roman, did you have a point you wanted to make?
Yeah, I'm good.
Okay. Jess, let's back up from the Ninth to the Eighth Amendment and talk about Grants Pass.
Sure. Well, Grants Pass, Oregon is a town of about 40,000 people in the Rogue River area of the state, and it passed some ordinances to deal with its homeless population that were fairly strict, and they made it unlawful to camp, but their definition of camping was sleeping in a public place with any accoutrement, like a blanket or in a car. And this was challenged by a public interest law group in Oregon, and it was a follow-up case to several others that had occurred in the Ninth Circuit involving a theory that punishing homelessness is an Eighth Amendment violation. It is cruel and unusual to punish homelessness if it's involuntary, because any punishment for an involuntary status like that would be cruel and unusual. And it drew back to a 1962 case the Supreme Court issued called Robinson versus California, where there was a California statute that made it illegal to possess or be addicted to narcotics. And what happened in that case was Robinson was convicted of being addicted to narcotics, but there wasn't evidence that he had possessed them. And the police knew that because he had needle tracks in his arm, so he was convicted of being a drug addict. And in that case, in 1962, the Supreme Court said, this isn't normally an Eighth Amendment question, but here it is, because any punishment for a status like this would be cruel and unusual. There's no punishment, just as being, punishing someone for having a cold or any other kind of condition would be cruel and unusual. Since any punishment would be cruel and unusual, this violates the Eighth Amendment. So drawing on that precedent, the Ninth Circuit wasn't the first. Actually, I looked into this during the, actually after, throughout the 70s and 80s and 90s, there were some federal courts that also ruled on homelessness and public camping type cases, finding under this precedent that those ordinances were unconstitutional. Those were all reversed by circuit courts, but in around 2003, the Ninth Circuit ruled in a Los Angeles case that the same precedent applied. It was cruel and unusual. Some Los Angeles camping ordinance was unconstitutional. That decision was vacated through a settlement with the ACLU, but the Ninth Circuit hadn't forgotten about it, and by 2017, when there was a case from Boise, Idaho involving a similar anti-camping ordinance, the Ninth Circuit actually issued an opinion saying under this Robinson precedent, it was unconstitutional. And the Supreme Court, to the surprise of a lot of people in the press room, turned down Boise, Idaho's cert petition. We thought that was like a certain, sure grant, and they turned it down. So it left it on the books, and it came back because cities across the Ninth Circuit found this a very objectionable precedent, not because many of them said they wanted to make it a crime to be homeless, but they felt that lower courts were using this to restrain all kinds of police action that might impinge on this concept that you can't be a crime to be homeless. So the case finally comes back to the Supreme Court, and Grants Pass, which is not the most generous municipality, was supported by some that actually are quite generous in addressing homelessness, including Los Angeles City, Los Angeles County, City and County of San Francisco, and the Biden administration, which noted that they had to clear out McPherson Square of a homeless encampment and said this type of restraining order makes it hard for us to have a complete, full spectrum approach to homelessness. So at the Supreme Court, we got a 6-3 decision, and Justice Gorsuch, showing the reverence he has for Justice Thurgood Marshall's jurisprudence, wrote an opinion that repeatedly cited a 1968 Thurgood Marshall opinion that refused to extend this Robinson case from '62. And that was a case involving public drunkenness. A Texas ordinance against public drunkenness. The Supreme Court plurality decision in '68 by Justice Marshall said maybe being an alcoholic is a status that can't be criminally punished, but being drunk in public is an act. You don't, some of us like to drink alone. You don't have to go in public to be drunk. So they refused to extend that precedent in 1968. Justice Gorsuch repeatedly invoked that to say, well, here we have a situation where homelessness itself is not being punished, but certain conduct is, and we cannot take this tool away from the local authorities who need to be able to use all options, both carrots and sticks, and sometimes they need to preserve public spaces for other uses, and so on. And so we're going to say this is not an Eighth Amendment violation. But also he was very critical of the idea that the Eighth Amendment applies to this type of situation at all. But he said, and this came up in oral argument as well, that while the Eighth Amendment, which typically applies post-conviction, doesn't factor here, there may be other constitutional provisions that do, such as due process. Maybe it is a due process violation to kick out or throw in jail everybody who has nowhere else to go, maybe. And maybe under state law, there's a necessity defense. I had to sleep in public because I had nowhere else to go. So he left open the idea that there may be certain other remedies or defenses or provisions that protect homeless people from arbitrary punishment. That wasn't good enough for the defense. They completely accepted the view that it is the ordinance in Grants Pass effectively criminalized being homeless. And they said the city can still punish people for all other things one might do, like sanitary issues or drug use or violence, or what have you. Those things all still can be punished. It's simply the fact of sleeping in public, which should be off limits for criminal sanctions. So that was Grants Pass versus Oregon.
Roman, I'm going to give you the last word on the First Amendment with the net choice cases and Murphy.
Perfect. Well, so the net choice cases are super interesting First Amendment cases that led to a kind of superficially unanimous court, but with a lot of divisions within it, both with respect to kind of like the procedures for bringing First Amendment facial challenges, but also especially with respect to the underlying First Amendment law. So just to back up, Florida and Texas, conservative governments in Florida and Texas passed statutes that were designed to rein in what they viewed as censorship by the main social media platforms and censorship against conservative viewpoints in particular. So they passed laws that limited the ability of social media platforms defined in various ways and different ways under the statutes to do content moderation in ways that would be disfavorable to ideological groups, including conservatives. They also had requirements, notification requirements that when you are being deplatformed or deprioritized or discriminated against with respect to the algorithms that are being used, you had to be notified. And this was justified in both states as an effort to sort of preserve free speech on the internet on those platforms. The Net Choice, which is an industry group representing all of the main social media platforms, and especially as the litigation sort of unfolded with a special focus on Facebook and YouTube, Net Choice challenged these laws as being facially unconstitutional, emphasizing the rights of the social media companies as intermediaries to curate the speech that's on their platforms. And the basic argument was that these intermediary companies were themselves First Amendment speakers with First Amendment rights, and that their content moderation policies, even when disfavoring particular ideological points of view, nonetheless was an expression of the social media platform's own ideological preferences and expression, and the government couldn't come in and limit their ability to curate and moderate the streams on their websites. The state said that these social media platforms didn't really have First Amendment interests here at all because they were intermediaries. They weren't really exercising expression themselves. The case was sort of litigated that way below in both California and, both Florida and in Texas. The district courts in both cases enjoined the statutes, but then the Fifth Circuit upheld the Texas statute and rejected the injunction. The 11th Circuit affirmed the injunction, and the cases both came up to the Supreme Court and were argued the same day, essentially, as a package. So the Supreme Court ultimately resolves the case, and there are two kind of major things that the court said or did. First of all, the court was unanimous on the idea that the lower courts had applied the wrong analysis when analyzing the facial challenge that NetChoice had brought. So facial challenge means that the law is unconstitutional, can't be enforced against anyone, it's facially unconstitutional. And the test in the First Amendment context, usually for facial challenges, is you don't have to show that it's unconstitutional in every individual application, but you have to show that it is unconstitutional in a very significant chunk of the overall applications of the statute, such that it shouldn't be able to be enforced against anyone. And that's the First Amendment overbreadth doctrine, sort of colloquially described. But the Supreme Court said, all 9 justices agreed, that the lower courts had not really done that facial overbreadth analysis correctly. Instead, what they had done was focus on Facebook's newsfeed page and the YouTube, the YouTube sort of standard interface, and only analyzed those applications of the statute, and basically held that done the First Amendment analysis with respect to those 2 things, as opposed to doing this broader look at what do these statutes cover more generally, and then what kind of percentage of those applications is unconstitutional. So 9 justices agree facial analysis was wrong, the motive analysis was wrong, and they vacate. They do so in 2 different opinions, though. Justice Kagan writes for 6 justices on this point. Justice Alito writes a separate opinion, sort of agreeing on this point with the majority. But the bottom line is that the court across the board is skeptical of facial challenges. And in this particular context, I think everyone kind of emphasizes that these laws the 2 laws are different. They include different provisions, and those different provisions are going to potentially apply in different ways to each different social media platform, which is going to want to do different things and may or may not be covered by the law, and may or may not have different interests. For example, when Facebook is curating its news feed and is applying arguably even an ideological filter on the news feed, that might be expression, whereas if Google is providing Gmail as a service to everyone, that might not count as expression that would be entitled to the same kind of First Amendment protection. And the court basically says that when you're trying to litigate a facial challenge, you have to have a fine-grained analysis at that level of detail of what exactly is covered and how it's affected. So that's the facial holding, and essentially it means that the 11th Circuit and 5th Circuit decisions are vacated. They've got to go back down and do the analysis again under the correct standard for facial challenges. Justice Kagan's opinion, though, goes on to say a lot on the merits, because Justice Kagan and the majority, now 6 justices in part, but basically 5 justices, they looked at the way that the 5th Circuit had analyzed the First Amendment issue in the Texas case, and they thought that that was an erroneous application of First Amendment principles and was too restrictive and didn't properly account for the First Amendment interests and rights of the social media companies. So Justice Kagan sort of resynthesizes the law of compelled speech, especially as applied to third parties that are curating or compiling the speech of others, and adopts a very intermediary protective view of the doctrine, emphasizing cases like the Miami Herald case, the PG&E case, the Hurley case involving a parade, where the parade organizers wanted to let some people march and some people not march, and the parade organizers were deemed to have First Amendment interests in choosing which third parties could take part in the parade. And Justice Kagan's opinion basically has a very speech protective view of the social media platforms' First Amendment rights as compilers and curators of other people's speech. Justice Alito, joined by Justices Gorsuch and Thomas, dissent on this point. They say, wait a second, these social media platforms are different from a parade. They're different from newspapers that get to curate who shows up on their editorial pages. And they say that the social media companies have a lot more power to censor, and that we might need to think anew about what the new sort of internet-based public square looks like when we're talking about speech, because the problems of censorship are potentially greater. And so Justice Alito's opinion says that, in his view, the court should not weigh into those issues because it should just send it back because the facial analysis was wrong. But to the extent that it does, Justice Alito's opinion is much more sympathetic to the efforts of Florida and Texas to regulate the social media platforms. The way it describes the facts, the way it describes the impetus between the laws, much more sympathetic. And the way it reads the precedents that Justice Kagan interprets, much more narrow in terms of the rights of compilers or curators of other people's speech with respect to the rights that the First Amendment rights that those compilers and curators themselves have. So very interesting decision, and it's a little confusing to see what's going to happen on remand. But I think the bottom line is it's basically a win for the social media companies on the merits with respect to the things that they care about the most, which are the main programs, the Facebook's news feed. I think that probably it seems like there's a 5-justice majority that thinks that those programs are constitutionally protected and can't be regulated. On the other hand, it's possible that NetChoice is going to have some challenges because they've brought this as a facial challenge, and the court across the board has signaled greater skepticism of facial challenges. So in this particular case, in its current litigation posture, it may be harder for them to get the result that they want, at least immediately. They may have to reconceptualize some of their claims.
Before you talk about Murthy, does anyone else want to weigh in on NetChoice? Okay.
And Murthy, I'll just say very quickly, I think an important decision, but it's a kind of procedurally based decision. Murthy is the jawboning case, also involving social media. The basic allegations brought by 2 states and 5 individuals was that the White House and other executive branch officials were leaning very heavily on the main social media platforms to censor certain types of speakers and speech. Speech about COVID, speech about vaccines, speech about Hunter Biden's laptop, all these kinds of politically sensitive, kind of controversial topics. And there was a lot of evidence that was introduced in the district court that White House officials and other federal government officials were on the phone constantly haranguing. It's disputed to what extent there were threats or implied threats that were made against the companies and the platforms. And the argument was made by these challengers that their speech was essentially censored by the social media platforms as a result of government lobbying and undue pressure. The court ultimately says that it's not going to weigh in on the merits because the plaintiffs don't have standing. And the court applies the traditional standing doctrine, but in a very persnickety way. Very detailed analysis by Justice Barrett, writing for the majority. And it says essentially that these social media platforms looked like they were censoring these people anyway. It's not really clear what role the government played with respect to the past censorship. It's not clear that they can connect the dots and show that the harmful effects experienced by the plaintiffs was as a result of the government lobbying. With respect to future harm, well, COVID was a while ago. Maybe it's not going to happen again. A little speculative. So the court essentially applies standing doctrine to say we're not going to get into the merits. There's a very strong, impassioned dissent in this case, again, by Justice Alito, again, sort of emphasizing the dangers of censoring people on the internet, this time focusing more on the role of the government, and saying that the majority's opinion has basically made it impossible to challenge this kind of government bullying. I think it's interesting just to bring in one last case. I'll just say quickly on it. There was a case involving the NRA that involved similar issues of government officials trying to pressure third parties to harm, in this case, the NRA, due to its political advocacy and its political views. In that case, the court was unanimous in supporting and ruling for the NRA, represented by the ACLU in that case, which was kind of interesting. But so the court was very protective of the speech rights of the NRA. I think the difference between that case and this case is the justices apparently thought that the linkage was not quite as tight between the government action and the ultimate harmful effects felt on the individual plaintiff.
Well, boy, we have just blown through our time. In the last just couple minutes we have, actually, there's one case that I would really like to get to, and Jen, that's Jarkissi. If you could finish out the last few minutes.
Sure. So Jarkissi versus Securities and Exchange Commission, this came up from the Fifth Circuit. It deals with securities investment fraud claims. So this idea of whether the Securities and Exchange Commission can completely internally to the commission charge someone with investment fraud. hear that, so they've made the rules about it, they're bringing the charges, and then they're prosecuting it and adjudicating it within their own tribunals, and then pronouncing civil penalties on someone for engaging in the fraud. And can all of that happen by the SEC before the individual has a chance to go to court? Or does the SEC have to bring that enforcement action in court? It should be noted that until 2010, by statute, the SEC did have to bring those charges in court. So some of these, this is not going back and uprooting longstanding agency power. This is newly given power, bringing lots more cases in their own tribunals rather than in an Article III court. The Fifth Circuit found this to be unconstitutional for 3 reasons. One, because the SEC judges, in their view, were not subject to enough presidential supervision because they can't be easily fired. Second, because the SEC has too much power to decide between whether to go to an Article III court or stay in-house. Finally, because this is a violation of the vaunted 7th Amendment right to a civil jury trial. And the 7th Amendment says in suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. So the Supreme Court essentially here affirmed the Fifth Circuit, but only on the jury issue. But this is a very significant victory for civil jury trial rights. And so really, really great, significant victories by the Chevron folks here in the crowd. This case, I submit, is going to have even vastly more impact moving forward, because although Chief Justice kept the case just to the securities fraud claims, already folks are talking about the other agencies who have claims and charges they bring in-house that look similarly. Also, I do think there's an interest in Congress to revisit whether we need to reinvigorate jury trial rights and just take away the statutory power of agencies to bring these cases in-house. The House Administrative Law Subcommittee had a hearing on this recently, and members from both parties were asking questions about what do we actually have to do to enable the Article III courts to hear these cases, which means people can have their have the charges, the civil charges brought against them heard and adjudicated by a jury instead of the SEC's own adjudicators. So I think it'll have significance moving forward, in part because it used to be, well, it's still the case under Chief Justice Roberts' opinion, that if something is known as a public rights case, then an agency has the right to hear it internally. If it involves private rights, we've always thought it has to go to an Article III court. The challenge is that over the years, the Supreme Court and the government has had an ever-expanding view of what is a public right. And rather than kind of the old school, like customs claims, how much do I owe to the government in a tax case, bankruptcy, that kind of thing. Just a like reorientation of government resources historically is what was public rights back in the day. It has expanded it to almost any case that involves a federal regulation. And so not only did the court reject that in this instance, but it essentially said any charge that looks like it has an analog to a common law claim, in other words, a claim that was around historically, heard by courts, that you have a jury trial right under the 7th Amendment to that, so it could be applied broadly. And then the final point is, I think the court made a move here that's similar to what it did in Dobbs, the abortion case, where it said, well, we've focused so long on our Roe and Casey line of precedent saying there is a constitutional right. What about our separate Glucksberg assisted suicide, no constitutional right line of cases? Let's resurrect those. Here, the court kind of minimized the importance of the precedent in Atlas Roofing from decades ago, authorizing apparently some of these public rights cases, and instead pulled out a Justice Brennan opinion, no less, in a case called Tull, finding there to be jury trial rights in a lot of these cases. So I think this is actually an instance where not only the court's ruling by re-resurrecting the Tull precedent could have lasting and broad impact, but it's also an interesting area where I think if one does want to see these things as political, there can be a lot of Democratic or progressive or more liberal lion folks in favor of jury trial rights, and a bit of alignment if Congress wants to kind of beat the court to the punch here and fix the statutes before litigants try to claim more and more of them to be unconstitutional.
So I guess we'll add Justice Brennan to Justice Marshall, and Justice Ruth Bader Ginsburg would be very happy with the results from this term.
Exactly.
Any final thoughts about the term? No? All right, well, we are officially out of time. So thank you very much. Please join me in thanking the panelists.